Hi, this is Jim Cunningham, and we're going to talk about dying without a will, and we're going to explain what happens in California. This is called intestate succession. Intestate succession, meaning without a testamentary instrument, which is a will, and we'll cover why we say will and testament in when we talk about wills, where that comes from. But what we're talking about here is if a person has no will or has no trust, and sometimes you do end up in probate court. Certainly you do if you have a will, but if you have no will and no trust, what happens? When somebody passes away, who gets what, and what is a court looking at, and what are the laws on a very high level in terms of who ends up with what assets? The state of California has this written down as a plan. This is California's estate plan for you. Every state has an intestate succession plan. And what this is if you make no will, this is what happens. This is who gets your assets. I would say from state to state, the laws are similar. They are not the same, but we do see similarity among laws, but you do have some differences. This is when you hear intestate succession, that means no testamentary instrument, no will or trust. So somebody they might have done a will. They might have tried to do a will or a trust, but maybe it did not meet the legal requirements for a will or a trust. Maybe that will was created, but then that person destroyed the will. They tore it up. That's a revocation of the will. But what we're talking about here is no valid last will or testament. And then we're going to figure out, we're going to go through who gets what. So if a person passes away, it depends if you're married, if you're single, if you have children, if you don't have children. Third cousins thrice removed might be part of the intestate succession, and we'll talk about how that works. So if you're watching this on YouTube, go ahead and subscribe to our YouTube channel and click the little bell. You'll be alerted to when our videos drop, and they drop about typically weekly at 6 p.m. on Thursdays on YouTube. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've been an attorney for over 30 years. I'm a certified specialist in estate planning, trust, and probate law, securities, and insurance licensed, and a pilot single-engine land. I'm not current. I'm an instrument rated. Also, I'm a real estate broker. So a broad background and a little bit of a learning junkie, if you will. I like to learn. I'm very inquisitive, learn new things. And we revisit old topics like intestate succession because we have a lot of lawyers at our firm. We're here to help people, and people do come in and they say, gee, well, what happens if I don't do anything? What happens if something happens to my kids and they don't do anything? Or what happens, my parents passed away and there's no will. What do we do? So we have 18 attorneys now dedicated to all things peaceful transfer of wealth from one generation to the next. So that is a fun area of the law for us. This is a disclaimer, very, very important. This is not legal advice. This is information. These videos on our YouTube page, we now have well over 200 videos. These are designed to educate the public at large. This is not a substitute for legal advice. So what happens when somebody passes away without anything, with no plan, with no last will or testament? This is dying intestate. And so what that means is without a testamentary instrument. That's what intestate means, intestate. Last will and testament. So after the Norman invasion of England in 1066, we're going back almost 1,000 years. There was this mashup of Anglo-Saxon and French and of course Latin laws that came together. So you will see many times in law cease and desist. Well, that's a Germanic word and a Latin or a French word, and the same with last will and testament. Will coming from willen, meaning to wish, in sort of old Germanic, and then testamentum, meaning will in Latin. So it's very common when you hear these two words together. The idea was that, from the 1066 to about 1500, they had some of the population speaking French and some of the population speaking Middle English. And so they had put both words in there. So technically it's redundant, but it's there for clarity's sake. And we sort of have this inheritance now of last will and testament. We still use that archaic language. Your assets need to belong to somebody else. That's what happens when you leave this earth, as we all do, and your heart stops beating and you're no longer living. You have stuff. that stuff is going to go somewhere. It doesn't just disappear. And that's what intestacy is all about. Who gets your worldly belongings? And it's a very important question for many people. And this typically subjects your loved ones to some type of process. It might be an affidavit, and we'll talk about what that is and how that process works. But also, in many, many instances, subjects your family, typically your family, going through the probate court process, which is expensive, it's time-consuming, and I think it's, what lawyers often don't talk about is it's just emotionally taxing and difficult. You're dealing with death. You might be dealing with some difficult family members. There might be a really good reason that your loved one did not do an estate plan. We see this quite often where it's a difficult family situation. They simply can't decide. And so they do nothing. I mean, that's the default, right? So a lot of people, I want to say it's about 40% of the population has no will or trust. So what is intestacy? When we talk about intestacy, it is a condition of estate of a person who dies without having made a valid last will and testament or other binding document, like a living trust. Now, spoiler alert, when you do create a living trust, you have a will that leaves everything to your trust. That is often called a pour-over will or a pour-over trust. And that is an important document in the whole estate plan. The intestacy is the body of law that determines who succeeds to your property, meaning who gets what you have when you die. So that day you die, all the things that you own that do not pass by beneficiary designation. So a lot of times an IRA, an individual retirement account, passes by beneficiary designation. Well, if that's a person and they're not your estate as the beneficiary, then that's going to be outside of the probate process. So California's probate laws, they prioritize the distribution of a decedent's estate to close relatives. Now, a relative within and if you're watching this on a video and not just listening to it on a podcast or driving, we have something called the table of consanguinity, which is basically the table of blood relations. So people with common blood, consanguinity is sort of the Latin for common blood or shared blood. This goes out to third cousin thrice removed, which would be a very, very distant relative. This would be your great grandparents' descendant. What is that? The 1, 2, 3, 4, 5, 6, seventh grandchild. So way out there in terms of potential heirs. And this is real. So, many times people pass away. They don't have children. They don't have parents. They don't have siblings. Now we're starting to look at cousins, second, third cousins. And that's when the table of consanguinity comes in. Another spoiler alert, who the person is that serves as executor on an intestate estate, which the legal term is administrator of the estate, is also based on this table of consanguinity. So very important to pay attention to that. So just very briefly, if you die without a will, who gets it? Well, if you have children and no spouse. So if you die without a spouse, your kids get it. Your kids inherit everything. And if you have a child who passed away leaving children, then it's split up among those as well. If you have a spouse but no children, no parents living, obviously we all have parents, but no parents living, no siblings, no nieces or nephews living, then your spouse inherits everything. So this is very important. If your spouse or registered, well, I would say state registered domestic partner in California, if there are no children, parents, siblings, nieces or nephews. So if it's only children, maybe if it's an only child who's the spouse that passes away, it all goes to the surviving spouse without a will. That includes community and separate property. Again, if you have children, parents, siblings, nieces or nephews, then we need to look at what's community and what's separate. But if you have parents but no children, spouse or siblings, the parents get everything, or the surviving parent gets everything, right? So if you have no spouse and no children, so if you're watching I might be describing your children. So I have 3 children. None of them have children. And so if one of them were to pass away and they did not have a will, my wife and me, we would inherit their estate. Now, they don't happen to have much because they're young, but that's where it goes. It does not go to the siblings. Now, could that child, make a will to leave their assets to siblings? Absolutely. They could leave their assets to anyone they want. But what we're talking about here is someone who doesn't make a will. Now, siblings, if you have siblings but no children, spouse, or parents, then the siblings inherit everything. So this is if you're living, your parents have passed away, and maybe you have a brother or a sister, you die with no children, no spouse, no parents, the sibling gets everything, whether you want that sibling to get it or not. And if you don't, then you need to make a provision. Now, this is where it gets a little uncomfortable, is if you are living with somebody and you are acting, you're kind of living as a married couple, if you will, but you're not married and you're not registered domestic partners, there's no basis to inherit on that. So you have to be registered domestic partner or married in order to step into that role as inheriting from your partner. So people, unmarried partners, it's no different than if you're watching this, you and me, the relationship that we have, there's no relationship, right? If they're unmarried partners. So very important to understand. There is no common law marriage in California. In fact, there's no common law marriage in many states. I think Montana may be the only state that has some form of common law marriage. Now, if you have a spouse and one child or a grandchild, the spouse inherits all community property. So this is where we get into community and separate property, and half of your separate property. So I die, and let's say I have no will, which for the record, I do have a completely funded living trust. But if I had no living trust, and I had one child, all the community property would go to my surviving spouse. Half of my separate property would go to the surviving spouse, and half of my separate property would go to my child. And if I have more than one child, 2/3 of that separate property goes to the children. So for example, if I inherited $300,000 and that's my separate property, and I died leaving 2 kids, my wife would get 100,000. She would get 1/3 of that, and each child would get 100,000. So the children get 2/3 of my separate property. The surviving spouse gets 1/3 of my separate property. This is regardless of what process there is in place, and we'll go through that. What are the court filings to get from point A to point B? But just understand, we do draw a distinction between community versus separate property. So a spouse inherits all your property and half of your separate property if you have parents. So let's say you're married but no children. So if I'm married and to my wife and I die with no children and I have separate property, my spouse inherits half of the property and my parents inherit the other half of my separate property, again, unless I have a will. And if you have a spouse and siblings but no parents, then your siblings. So if I had a sister and I died and my parents were deceased, I had no children, I had that 300,000 in separate property. My wife would get 150,000 and my sister would get the other 150,000. And that's the way it is, right? So it depends. What we're paying attention to is siblings. We're paying attention to parents. We're really paying attention actually to nieces and nephews as well. Half siblings, the 120-hour rule, no heirs, and the personal representative. So half siblings are treated the same as full siblings for the purposes of an intestate succession for inheritance purposes. So it doesn't matter if you're, if you got a half sibling here and half sibling there, they're all treated as full siblings. If a beneficiary dies, so if someone who's set to inherit dies within 120 hours, like so if I die and then, I have a spouse who dies within 120 hours of my death, a little bit like Gene Hackman and his wife, and I know that's been in the news lately, when they died because it mattered, then they're deemed to have predeceased me. So if I die and then 10 hours later my wife dies, my wife is deemed to have died before me, so her estate does not get that separate property or community property. Well, they don't get the separate property. She would be deemed to have died before me. Now, if she lives 121 hours, right? Then it's a different set of rules. So this is where time of death becomes material. We don't really see this a whole lot, frankly, in the real world. Now, the other thing about this is you can address this in the estate planning documents. So if you do a will or a trust, we typically do address what happens if somebody is set to inherit, but the gift is not distributed. So if I inherit from my parents and then I die before the complete distribution of those assets, that inheritance to me. So like my parents die and then a month later I die, in that estate plan, we're typically providing what happens if you do not survive the distribution. So if you survive that 120 hours, what ends up happening is that is then distributed to my estate if I died after 120 hours, unless the document itself addresses that internally and says, look, if Jim dies before this is fully distributed, then the money goes somewhere else. By the way, there's no standardized methodology of doing this. These are really just best practices on the estate planning side from the lawyer. If there are no heirs, the estate escheats or goes to the state, meaning if you die without any, you have no heirs, it goes to the state. This only came up once in 30 years of practice. We had a client born in 1905, so this is a while ago. A client born in 1905 in Russia. Well, 1905 in Russia included most of Eastern Europe. And of course, 2 world wars destroyed a lot of documents. We basically could not even track down who his relatives were. And in that case, we did end up finding a very distant relative who ended up getting everything, and it was a fairly substantial estate. So that did not go to the state of California. But it does. If you don't have any relatives, it does go to the state of California, but we really don't see that too often. The personal representative has an order of priority. So what does this mean? Well, if a person passes away and a court needs to appoint someone as the executor, really the term's administrator when it's an intestate estate. So if you see the term administrator floating out there, that is a tip that it means intestate estate. Now, there's a special administrator. There's administrator with will annexed. Those mean different things, but what we're talking about here is administrator. There's an order of priority, and that's found in California Probate Code Section 8461. The surviving spouse is in the #1 priority. So if you're watching this and maybe you have a stepmom and your parent died, right? So you have a parent died and you have a stepmother, that stepmother, and there's no will, that stepmother's going to have priority, even though you inherit from your parent. And if you don't get along with your stepmom, you can see where that can cause some problems. So very important to there's a lot going on here. And if your assets are of a certain amount, and we'll talk about that, it really does make sense to get some legal counsel on what your rights are and what the process is. As you can see, it's not really clear. Community versus separate property. So community versus separate property. Why is this important? Well, if you've been divorced, you know it's very important. Even if you haven't been divorced, it sounds like it's probably important. But in California, only married people or people who are registered, and I would stress state registered domestic partner. So California has this a 2-track spousal system. Basically, you can get married or you can be a registered domestic partner, and they've really removed all the restrictions. The use case for registered domestic partner is if you are receiving Social Security benefits or other retirement benefits or other survival benefits because you were married before and your spouse passed away. That's where you really want to pump the brakes before you just jump in and marry somebody, because you may lose some of those survivor benefits. So being a registered domestic partner is like being a spouse in California. In fact, those terms are interchangeable. So you have all the rights of a spouse. You avoid property tax reassessment when a registered domestic partner dies and you take that property, but you also don't lose the survivor benefits. And you also lose your portability, which is that extra $13.99 million estate exemption you might have inherited from a surviving spouse. So very important considerations, kind of outside of the scope of what we're talking about here, but very important to pay attention to that these community property rules they apply to both state registered domestic partners as well as spouses. So all assets acquired during marriage are presumed to be community property, except assets acquired by inheritance or gift. Assets brought to the marriage are separate property. They can be transmuted. They can become separate property. So community property, each spouse is entitled to the whole. Now this comes, community property laws come by way of Mexico, right before the Mexican-American War, when California was part of the country of Mexico, which in turn come from Spain. And I believe this comes from Islamic law, where basically women could own property under Islamic law and through Spain. So this very old kind of twisted path to get to community property. But under community property, understand that each spouse is entitled to the whole. So each spouse owns 100% of the property, and that is shared. So it's part of the community. So in California community property law, we talk about the community. So if you hear that term, the community, that is talking about the assets that form community property. So this is income is all property acquired during marriage, right? Income would be one of those things. If you buy real estate, certainly if you use your income to buy real estate, and personal property purchased with marital funds are all considered personal property. At divorce and death, community property is generally divided equally between the spouses. So, at divorce, community property is divided between the spouses. At death, the surviving spouse succeeds to the community property in the absence of a will. So if the deceased spouse does not leave a will. So Hal and Wanda use Wanda's earnings during marriage to buy a home solely in Wanda's name. The home is community property. So if Wanda dies, Hal needs to go to court to get that property in his name. So just because you have property in your own name, so, Wanda's out there working, she deposits her paycheck into a bank account that's only in Wanda's name. That is not separate property, because that is property that was earned during the marriage, and I'm assuming no prenuptial agreement. So all property acquired during marriage is community property. Separate property are assets that you bring to the marriage, as well as gifts made during the marriage. And then separate property may not end up going 100% to the surviving spouse. So this is very important. So there's this fork in the road, and any competent probate lawyer, when you have a spouse die and there is no will, one of the very first questions they're going to ask you is what's your community property and what's your separate property, because they go in different directions. So inheritance, if you receive an inheritance during your marriage, it's separate property. Personal injury settlements can be separate property if they compensate for personal losses. Stocks and bonds brought before marriage, and certainly gifts during marriage or before. So I guess the classic example would be an engagement ring. Well, that's a separate property asset. So Hal unexpectedly passes away, leaving behind substantial separate property assets: $1 million inheritance, $50,000 from a personal injury settlement, $500,000 in Amazon stock before his marriage, and an inherited Malibu beach home they plan to visit for the first time next week. But Hal dies unexpectedly after receiving this inheritance. Without an estate plan, the laws of the state of California control the laws of intestacy. Wanda must split the separate property assets with the son, Sonny, whether that's her son or not. And that would be split according to laws of intestacy. Those separate property assets would be split 50-50. So instead of Wanda receiving, a little over $1.5 million, she receives a little over $750,000. And this leaves her without an ability to retire. So she's got the $1.5 million plus the beach house. Who knows? Maybe she can sell the beach house and make some money. Gifts between spouses. Let's say Hal gives Wanda a very nice watch. And if you're watching this on video, I just Googled most expensive Rolex watch, and this thing is about $120,000. A lot of diamonds on it, a lot of bling. Under California Family Code Section 770 and 852, the gift can be treated as Wanda's separate property if Hal intended to make a gift and there is delivery and acceptance. Well, it's really easy. Wanda says, "Thank you so much," kisses Hal, and puts it on her wrist. That's pretty much acceptance, right? This is kind of an easy one. There's no written agreement required to transmute this to separate property for tangible gifts. Now, if you have real estate or other major assets, sometimes you would definitely want a writing for clarity. Now, this is very important because separate property, if there's a death, then this is Wanda's property. So Sonny in our prior example couldn't come in and say, "Oh yeah, I want half that watch." I don't know how you'd split half a watch, but I want half the value of that watch. Well, no, that was Wanda's separate property because it was a gift from Hal. So commingling of separate property. Commingling is where you have separate assets, and then what happens is you have separate property, and then you put community property into the separate property. So you can have a savings account. So let's say you bring a savings account to marriage, and then you add to that savings account with your earnings. And that may be the earnings of the spouse who brought that account to the marriage. Well, that account then acquires over time more and more of a community nature. There's actually a math formula that our computer program, software program called DissoMaster, was built in the 80s that family law attorneys still use to calculate who gets what. Real estate, this can get more complicated if you own a house before marriage and then you use community funds to pay the mortgage. The interest is one thing. The principal's a little bit different. The community starts acquiring an ownership interest in that house. And so that becomes a very complex formula. And certainly business interests. If you're continuing to work in the business and build value, even if it's a separate property business you brought to the marriage. One way to cure a lot of these problems is, with a good estate plan, we'll talk about that. Also, potentially a prenuptial agreement, or a postnuptial agreement, but some agreement between the spouses that lays out what is in fact community and what is separate. So why is intestacy so bad? And this really begs the question, what is probate? Probate it's been called a lawsuit you file against yourself to protect your creditors. So it's the process of administering a deceased person's estate, decedent's estate, when the decedent left a will or not. So if you have a will, you're going to probate. If you don't have a will, you're going to probate, except with a will, that's a list of instructions to the probate judge about who should handle your estate and who should get what when you die. Intestacy, the judge decides who should act as your administrator, which you kind of think of that as an executor. And then the judge determines who should succeed to the property, who inherits the property based on relationship and based on whether it's community or separate property. So what is the purpose of probate? Probate is from the Latin probare, to prove, which is to prove up the validity of your last will and testament. That is not a binding legal document until a judge makes an order in probate court. that it is. A living trust, on the other hand, is a valid document from the get-go. This is supervised, at least in California, for the what we call formal probates. It's not where you put on a tuxedo, but these are probates that last 16 to 24 months on average. And there's a lot of court involvement, heavy court supervision. These are supervised by the court. The the executor in a will, or the administrator under intestacy, is the personal representative appointed by the probate court to manage the affairs of the estate and the decedent. And then you're required to file an inventory of the decedent's assets. The California probate referee, the person who is appointed by the court to value the assets. The executor is the one who, with the attorney, the executor or administrator, create the appraisal document that then the probate referee fills in, and then that is signed and filed with the court. Once the debts and taxes are paid and all of the affairs are wound up, the estate is in a condition to be distributed, and that is done following a court order. That all takes 16 to 24 months realistically. Probate is necessary when there is no fully funded living trust. So sometimes we go in under the Hegstad or Ukstad cases. I'm not making these names up. These are great Norwegian names. Happen to be two Norwegian families, totally unrelated to each other, that did not have a fully funded living trust. Hegstad is when an asset was in the trust, okay, but then maybe got out of the trust because you needed to refinance the property. That was actually the case. Ukstad, the property was never in the trust, but listed as a schedule or somehow otherwise assigned to the trust, but there was no deed putting the property to the trust. We covered this in other videos. How do you get real estate into a living trust? Well, you sign a deed, right? So Jim conveys the property to Jim as trustee of Jim's trust, and you record that deed at the county recorder's office, and that's how you fund a trust with real estate. So if you have a will or no will, you're in probate court. Now, it's getting a little more complex in 2025. We look at the amount. So if you just have a cash account of $100,000 outside of the trust, after 40 days has elapsed, 40 days and 40 nights, then the executor or administrator or successor trustee can sign a document saying, hey, put that $100,000 into the trust. In 2025, April 1 of 2025, we're looking at that limit. So there's a cap on that, 184,500. It looks like it's being raised to about 200. I don't think that number has been finally released because we are in April 10th, which is not 40 days from April 1st. So the California Judicial Council does not have to release that number until sometime in May. So we're waiting with bated breath on what that final number is, but that's the amount that can pass by affidavit and not a court process. The other thing that popped up recently, and again, effective April 1, is if the family home, right, if the residence has a market value of $750,000 or less, you can go through a single hearing probate court proceeding. So that's good news. I mean, it cuts the amount of legal work involved in many cases, but we'll remain to see, is that a good thing for families that don't get along? I'm not sure it is. Probate court's the only way to sell or dispose or otherwise transfer a decedent's property after death to the people entitled to it if there's no living trust. That's just the bottom line. This is public. All of these filings are public, and they are creditor focused. What does that mean? That means, unlike a living trust, with a living trust, there is no duty to notify creditors. With a probate, you must notify known and reasonably ascertainable creditors. That is the single biggest difference between probate and a living trust, is you must notify creditors. You can if you have a living trust, but you're not legally obligated. So the focus on a living trust is providing for the beneficiaries, so typically the family, and probate, the primary focus is not on getting money to beneficiaries, it's on paying creditors. So those are two. I would say that's the big difference between probate and trust administration, is the creditor focus, which, I mean, a lot of people they would rather take care of their family than, some person who claims to be a creditor who might have a flaky creditor claim. So if the kids want to sell mom's house and mom's passed away, mom can't sign the deed. She's not here, right? So the court appoints someone to sign on her behalf. There are 10 exceptions to probate. We cover that in other webinars, but we'll cover a couple of those in just a minute. So why is probate bad in California? Well, it's time consuming, 16 to 24 months. It's expensive. It is 4 to 8% and sometimes 100% of the assets of the estate. And it's a public proceeding. So when is it 100,000? When is it 100%? Well, a $3 million estate has 86,000 in 43,000 in attorney's fees and 43,000 in executor fees. Well, if you have 3 million in assets and 2.5 million, the 2.95 million in assets, meaning you have very thin liquidity, right? The 86,000 in fees basically is the entire equity in the estate, right? So the fees are fixed on the fair market value of the property, not the net value after encumbrance. So estate taxes are figured on the net value, but the probate is figured on the gross value. So again, if you have $1 million home and there's a $950,000 mortgage, these fees are about $50,000 with the attorney and executor fees. So really leaving nothing for the heirs. What happens to real estate without planning? So specifically real estate, and this is where title matters. So there are a lot of different ways of holding title. And if you're buying real estate and in California, and you're typically, you're going to go through an escrow company and a title company. If you're married, there are 9 different ways to hold title in California. If you're single, slightly less. But a lot of different ways. And I remember when my wife and I bought a home a few years ago, I was like, wow, there are 9 different ways. I forgot about this, right? Because it's been a while since we bought a piece of real estate. So there are different ways to hold it. We're going to go through each one of these. So individual or sole owner. So that is if Jim owns the house, I have the sole right of possession. It's in my name. I can convey that property, right? There's no restriction on it. And then whoever the purchaser is becomes the owner of that property. And in the Anglo-American system of property ownership, I cannot put restrictions typically on those deeds to say, well, this can only be sold to someone whose name is Jim and whatever. It goes to that subsequent purchaser. And then at my death, if just my name is on title to the property, that is subject to my will. So even if I have a living trust, this property never made it into my living trust and there was no assignment to my living trust and it's in my name, my will would leave this property to my living trust, and that would require a probate. And if there is no will, then it goes to on intestate succession. And then the court needs to determine, because I have children and I'm married, what portion of this is separate, what portion is community. And then we may end up having 2 proceedings, one proceeding to get the property to the spouse and another proceeding to get that property to the children. So the interest can be creditors. The interest, if I have creditors, they can seize that property and the creditor can become an owner. And then the presumption that the property is owned by the living trust. When we put it in the living trust, when it's my name as Jim, as trustee of the trust, then the presumption is that it is in the living trust. So again, we're talking about intestacy. This is in part designed to talk to people who are thinking about doing estate planning. And by doing an estate plan, you can if you put that in a living trust, you can keep it out of the probate. So Oscar owns Blackacre. Oscar dies with a simple will. Victor's name as executor and sole devisee heir of Oscar's will, and hires Cunningham Legal. So Victor hires Cunningham Legal to represent Victor in the probate court. And 16 months after hiring us, the probate court the probate proceedings concluded, and the court orders that the property be distributed to Victor. And so what Victor does is he signs a deed, a personal representative deed, transferring that property from Victor as executor of Oscar's estate to Victor, an individual. And so now Victor is now the sole owner of that property. Now, what Victor should do is he should think about doing a revocable living trust centered estate plan so that when he dies, that property doesn't have to go through probate again, right, for the family. So community property, only spouses and registered domestic partners. And again, I would say state registered domestic partners. Before there was a statewide registered domestic partner procedure, people did it through certain municipalities. San Francisco and Oakland were a couple of them. Some counties did it. And so now I would say if you are not a state registered domestic partner, you really need to look into that because if you're a registered domestic partner, you want to make sure you have that nailed down. And that's kind of a topic for another day, but just something to pay attention to. Equal ownership and managerial interest. So if my wife's name is Lori, if Jim and Lori own the property as community property, that is the community owns the property. I have an undivided interest to the whole, and my wife has an undivided interest to the whole. That's how it is. The management is unified and it's equal. It's equal management. Any transfer requires written consent of the other spouse. So This is why you might see, so if I own property just in my name as Jim Cunningham, and then I go to sell that property to you and I'm married, the title company is going to require a quitclaim deed from my spouse. Okay. This is why sometimes you see these quitclaim deeds from spouses, a quitclaim deed from the spouse to either me or to the buyer, right? Because they want to make sure that I'm not, because I can convey my portion of the community property, but then if she doesn't agree with it because she has equal control, even though title's in my name, that's why you might see that quitclaim in there. I know it's a little granular, but that comes up quite a bit with clients. Again, one spouse can own 100% of the community property, meaning it's in the spouse's name, not in the other spouse's name. And on death, if the property is owned in the deceased spouse's name, half goes to the survivor, right? So if I die with a property that is community property just in my name, half goes to my wife, and then half is distributed under my will, which says it goes to my wife, so she gets it all. The successor status is tenancy in common. So if I left my half of the community property to my 3 kids, my wife would be a tenant in common with her 3 kids because we share those kids together. So that would as how the successor looks. Creditors do have rights, liability for debts of either spouse. Title determines outcome at death, but not divorce. So this is where it gets a little tricky. We'll talk about this with joint tenancy. This is where it can get particularly problematic if you have joint tenancy with a non-spouse and you're married. So Oscar conveys Greenacre to Abel and Baker, spouses as community property. Abel dies without a will under California's laws of intestate succession. Baker inherits the property at death because Baker is the surviving spouse. Abel could leave Abel's half of the property to anyone by will. So Baker hires Cunningham Legal to initiate a spousal property petition in the county of Abel's California residence, not necessarily where the property is located. And then we guide Baker through the process. And after one probate hearing, Baker then owns 100% of Greenacre. So that's how the process works. Community property with right of survivorship keeps you out of probate court. At death, the interest passes to the survivor, and the right of survivorship may be terminated, so unilaterally by one spouse, but it can only be used when 100% of the property is owned by the community spouse. So you can't have like the community property with right of survivorship on a third and then another person, or 2/3 and another person owning a third. Creditors do have rights, so some creditor issues there. And then survivorship must be expressly stated. So community property with right of survivorship. And then so in our case of Abel and Baker, Oscar conveys Greenacre to Abel and Baker, spouses as community property with right of survivorship. Abel dies without a will. Because of the title, Baker inherits the property at death because Baker's the surviving spouse. Baker hires Cunningham Legal to prepare an affidavit. So this is not a court hearing. It's an affidavit that's recorded with the county recorder where the property is located. And then we guide Baker through the process. And after recording the affidavit, Baker then owns 100% of Greenacre, Baker's name, and is sole owner without having to go through probate. So if you're choosing between community property and community property with right of survivorship, that's the difference, is you don't have that court proceeding. Now, that may be a good thing. It may not be a good thing, depending on what your estate plan says. But I would say for most of our clients who have a living trust, they're not doing community property with right of survivorship. They're just putting it in the trust. Joint tenancy, any number of human beings with heartbeats can be joint tenants, but they must be human beings. Equal ownership interest, you can have halves, thirds, quarters, fifths, but it's all equal. And they all have to go on title at the same time. They all have equal right of possession. And the transfer severs the joint tenancy as to that joint tenant, and the new owner becomes a tenant in common. So if you have 3 people in and one person conveys their interest, that new third person coming in is a tenant in common. So the other 2 do not get that new third person, right? That new person, and they're not going to inherit that by survivorship. At death, the interest ends. So it's the last man or last woman standing gets the property, and the creditors have rights, and they can force a sale of one of the joint tenant owners. So if you 3 people go in on a house and one's got some creditor issues, that creditor can force a sale of the entire property, and it must be expressly stated as joint tenants. Now, Texas, joint tenancy has to say joint tenancy with right of survivorship for there to be a right of survivorship. So that's not the default. California's default is a right of survivorship. Oscar conveys Blue Acre to Charlie, Delta, and Echo as joint tenants. Charlie's unmarried and dies with a will and living trust that leaves everything to Charlie's children. Delta and Echo still inherit the property because that joint tenancy property was never funded into the trust. So the full value of the joint tenancy property is included in Charlie's estate for estate tax purposes. unless it can be proven that Delta and Echo contributed money, so that there's a burden shifting there. And there's a 1/3 adjustment in cost basis at Charlie's death, meaning Charlie's his third interest, the step up in basis to the fair market value that helps Delta and Echo potentially with some capital gains taxes. But Delta and Echo own the property. Tenancy in common is any number of persons, living and dead humans, LLCs, partnerships, corporations. So joint tenancy, human beings with heartbeats. Tenancy in common, you can have non-human persons. And it sounds weird, a non-human person. A little bit like, I forgot the guy's name who was running for president. Mitt Romney talked, well, corporations are people too. That's what we're talking about here. These can be equal or unequal. It can be 90-10. It can be 50-50. It can be whatever you want, but the numbers should add up to 100. You want to check your math on that. Separate legal title is to undivided interest. So it is an undivided interest, meaning you have the right to the whole. Equal possession, if you're on there for 10%, you have a right to occupy the whole, even though you're only entitled to 10%. So if it's 10 acres, you're not going to be confined to 1 acre. You can roam around all 10 acres. Each interest must be conveyed separately. So not meaning you can add someone as a tenant in common. So if I own the property 100%, I can convey 10% to somebody, and now we're 90-10. That's tenants in common. That is not joint tenancy. At death, the interest passes by will, and heirs become co-tenants, okay? So, and I'm putting heirs in quotes because if you have a will, technically it's the legal term is devisee, not heir. Heir means literally there is no will and you are an intestate heir. But again, if you're a co-tenant with other people, you're going to end up being partners with whoever inherits their portion of the property. And there is a presumption of tenancy in common in doubtful cases. So if it's a little ambiguous, the default is tenancy in common. So if someone tried to do joint tenancy, so let's say I have a property and then I transfer a property to a portion of the property as joint tenants, or it's like 90-10 as joint tenants, you ignore the joint tenants and it will be tenants in common. So remember, joint tenants has to be equal. Oscar conveys Red Acre to India, Juliet, Kilo, and Lima, LLC. So 3 people in an LLC as tenants in common. India dies with a will. So one of the humans dies with a will. Mike, India's son, is named executor and sole devisee or heir under the will. And he hires Cunningham Legal to represent Mike in the probate court to admit India's will to probate court. 16 months after hiring Cunningham Legal, the probate is concluded, and the 25% interest in Red Acre that was part of India's estate is ordered by the probate court to be distributed to Mike. And then we prepare a deed for Mike to sign, a personal representative deed that transfers it from Mike as executor of India's estate to Mike, an individual. Now, Mike owns 25% with Juliet, Kilo, and Lima, LLC. Juliet, Kilo, and Lima, LLC may never want to be partners with Mike, but they are partners, right? They're quarter interest, and that's how it works. Change in ownership is very important for Prop 13 taxes. When there is a change in ownership, property is reassessed. Death is a change in ownership. Let me repeat that. Death is a change in ownership. Now, if you're a spouse or surviving registered domestic partner, transfers between spouses and registered domestic partners are not changes in ownership. Just that statutorily, that is not a change in ownership. I know it sounds a little weird, but the property is going from one person to another. But apparently that's not a change in ownership because of the legal status of the deceased person when that event happened, when that death happened. So if Owen sells Greenacre to Abel for $1 million, obviously a sale is a change in ownership, right? I'm going to give you Greenacre, you give me $1 million. That's change in ownership. Owen leases Greenacre to Abel for 20 years with 3 5-year options. That is a change in ownership. Long-term leases are a change in ownership. If it's over 30 years, a change in ownership, and then mom gives the family home to daughter or sells it for $1 to the daughter, that is a change in ownership. Certainly when mom passes away, it's a change in ownership. When there's a change in ownership, property is reassessed. So Prop 13, very important, valuable property right. This is highly relevant when it comes to intestate succession because many times people will say, well, mom died 10 years ago and we haven't done anything. There was a change in ownership 10 years ago. That property gets reassessed at death unless an exclusion applies. And sometimes they'll let you file a late exclusion, but there still might be some back taxes in there, right? They still might reassess you for a period of time. So Prop 13 passed in 1978. What it did is it amended the California Constitution. It rolled back property assessment levels to 1975 levels. People used to pay 2.6% on average of the market value of the property in tax. Then it got cut to 1% of assessed value. Assessed values can only go up 2% a year. So if you bought that condo for $25,000 in 1975, your property taxes are probably under $1,000 a year, right? If someone buys that condo today, their taxes are $6,000. We'll have a slide on that. So they're a lot more for newer buyers, right? So if you have had real estate for a long time, you understand that. If you've had property a long time, you know, if mom's had that property a long time and then mom dies, that property's going to, especially now with Prop 19 that took away, broadly speaking, the parent to child reassessment exclusion, you're going to have a tax reassessment in there. So it's something you need to get your head around. It means you're going to inherit less money and then more money's going to the county for property tax. So property's fully reassessed when there's a change in ownership. And we've got an example here. We've got 3 families. So these are condos in Todd Ranch in Ventura, where I spent some of my childhood. Grandma and grandpa bought their condo in 1975 for $25,000. Mom and dad buy their condo in 2000. And then daughter and spouse buy their condo in 2025. Each condo is 1,449 square feet. They're exactly the same. They're 3-bedroom, 2-bath. They are different taxes. So grandma and grandpa's assessed value is $67,000. Mom and dad's is $200,000, and the daughter's is $600,000. So same exact condo. I mean, in law school, they told me every piece of property is unique. I don't know about these condos. They look one looks kind of the same as the other. But look at the difference in property taxes, you know, under 700, 2,000, and 6,000 for the same property. So if the grandkids are inheriting the parents' condo and they go, oh, well, the taxes are only $673 a year, they might bump up to 6,000. So you got an extra $5,500 in a year to pay in tax. So it's just something to get your head around. So what happens to business assets without planning? I can tell you it is not pretty. So title, if title's in an entity, a partnership, LLC, or corporation, meaning assets are owned by a corporation, and then the person who owns these shares of the LLC or owns the business passes away. So we have to look at a lot of different things. Not only do we have to see if there's a will, we also need to look at the operating agreement or the bylaws or the buy-sell agreement or the corporate documents. We're going to have to take a look into those. I would say a lot of probate practitioners aren't as strong on the corporate side. Traditionally, the trust and estate people, I would say a lot of times they stick to, they kind of limit the scope of their practice to non-corporate matters. The corporate practice tends to be an additional subspecialty. And in our firm, we happen to do both because we're a little bit larger. We can handle both the estate stuff and the business as well. We've got attorneys in both camps. So you do need to look at the operating agreement on the LLC, and also what are the rules, who can be admitted as a member, maybe the intestate heir. So if you're a manager of an LLC and one of your members dies, you need to look at that LLC document, because the other partners may say, you know what, we wanted Jim as a partner, but gee, we don't want Jim's spouse because that spouse isn't really bringing any value, and Jim was a real integral part to this. So we'd rather just cash the spouse out. So these are some of the things. This is not just something where if a person succeeds to the property like they do as a tenant in common, right, where they just automatically become an owner. There's no automatic becoming an owner when it's a business entity. So without planning, the business assets are likely going to be subject to probate court, which is that court supervised process. It's lengthy. I will tell you, probate judges don't know nearly enough about the business that's going on as they should. But they're busy people, right? They're handling a lot of different matters. So that's why you appoint an administrator or an executor to handle that. Still, it's court supervised. Accounts are often frozen during the probate process. This can be really difficult if you have to meet payroll. So this happens frequently. You get the panicked call, maybe from a surviving spouse, maybe from a child, saying, look, we have to make payroll and there's no one who has access to the checking account. We need to go in and get emergency authority from the court in order to make payroll, right? In order to pay people. And that's pretty important, right? Got a lot of people relying on getting paid. The day-to-day operations often suffer because there's no designated individual to take over. So if you have a business, you should have a buy-sell agreement, some type of succession plan. If you're not there to do and act on behalf of the business, then you really need to have somebody in there who can act on your behalf outside of the probate court, right? So this is about estate planning. In many instances, the business is sold or liquidated. If you're a dentist, that dental practice must change hands within 30 days, or by law, it must shut down. So this is a carve out for dentists because you're holding on to apparently a lot of drugs. I mean, I think that's basically it. It's a DEA thing, I think. You have to have that business, that dental practice transfer to a successor, or it is shut down. So we learned that when one of our clients passed away suddenly, who was a dentist. So John, the owner of a successful family-run manufacturing business, unexpectedly passes away without a succession plan, and chaos ensues. His heirs are thrown into a probate court battle, each with conflicting ideas on how to manage the company. Operations are stalled, and no clear leader emerges. This causes key clients to do what? They're taking their business elsewhere. They're out of there. Employees are worried about job security. They start leaving. They start looking for new employment. And really, the business is sold for peanuts to pay its debts, and the family legacy crumbles, and legal fees mount, and the personal relationships are fractured, leaving a once thriving business in ruins. This does happen, and it's sad, frankly, because with a little bit of planning, I think a lot of this can be avoided. So how can intestate problems be avoided? Let's talk about avoiding them. Hint, it's savvy estate planning. So an estate plan involves a living trust, a pour-over will, typically a durable power of attorney for property, durable power of attorney for healthcare, HIPAA authorization, deeds to the properties. We covered this in other videos, and I would encourage you to take a look at those, how to craft an estate plan. So a living trust is a lot like a bucket. So you create this bucket, it's got a handle, the trustee holds onto the handle. The trust itself is this bucket. I mean, obviously trust is a document, it's not a bucket, but I'm trying to help you out here. You put your house, stocks, bonds, mutual funds into the bucket. IRAs, 401ks, life insurance, annuities stay outside of the buckets, out of the bucket. All trusts have a trustee, a beneficiary, and a corpus or stuff. So a trustee is a person who's holding onto the handle. You've got the bucket. While you're alive, your living trust, you're the beneficiary of that, right? You might be the trustee holding onto the handle. You're also the beneficiary. But if you stop being trustee, let's say you're not dead, but maybe you have a stroke, that bucket then passes to your successor trustee, that person drops the term successor. They become the trustee. You're still the beneficiary. So those assets are used for your benefit. And that's really how it works to keep you out of probate court. That does not require court intervention. And it's a much more effective way of managing your estate than relying on the probate court system, which is really kind of the last resort. So trusts take care of your assets while you're living. They avoid probate at death. There are little used strategies, broadly speaking, with other lawyers that we use a lot in our firm to protect assets when those assets pass to your heirs from their divorce, taxes, and lawsuits, the creditors, predators, and divorce. And a revocable trust typically becomes irrevocable or irrevocable at death. So a revocable trust can be amended during lifetime, an irrevocable trust cannot be amended. So we have an example here. If you're watching this on a video, we have Abel and Baker. They create a living trust, the Abel and Baker Smith. They create the Smith Trust dated April 10, 2025. The trustees are Abel and Baker. When Baker dies, all of Baker's assets go to Abel, then Abel dies, and then there is what we call trust administration, both when Baker passes away, the first passes away, and then when Abel passes away. What is trust administration? It's where you pay debts and expenses and you remove a deceased person's name from assets. You might value the assets, right? Because you get adjusted cost basis. So that stock that you paid a little bit for that's now worth a lot. When Baker dies, Abel, if it's community property, Abel can sell that stock and not pay any capital gains taxes. Pretty cool. And then once Abel dies, we go through trust administration again and make distributions to the children. The benefits of a living trust: avoids probate, avoids the hassle, delay, expense of probate, maintains privacy. This is something, 30 years in practice, I'm valuing more and more is the private nature of estate planning. We're awash in information in the world, and it's only getting more accessible as time goes by. And think about it: the date a person inherits, the amount they inherit, their address, sometimes their phone number is all a matter of public record. And so that's something where a lot of people want to keep that private for a lot of different reasons. And really, the living trust helps protect your legacy in a way that a will simply doesn't, or no plan doesn't. So living trust definitely a better way to go. So I'm a parent. We've all been there. Our adult children may be dragging their feet with adulting. So health insurance paperwork, oil changes, job applications, getting your retirement account set up, going to the dentist. I mean, if you have kids who are, maybe out of school, and not quite fully launched. They're in there, maybe their 20s, maybe 30s. Many younger adults have not created basic estate plans. Life's unpredictable. Accidents happen. Stuff happens. I would say that if you're a parent of adult children, your adult children should consider doing estate planning. Now, it may be just a will. Like if they don't have much assets, right? If they only have 100,000 in assets, maybe a will's enough. Certainly the durable power of attorney for property management and personal affairs, and the advanced healthcare directive. Probably the most important one is the advanced healthcare directive. That's something we can provide in our office. It's also readily available for download for free, right, in California, where you can download the California statutory form power of attorney for healthcare. That's something you really want to have your kids look at and name somebody, whether it's you or a sibling or somebody else. It's something they should have because you won't have access to their health information if they do have a health emergency. So Emily, a 28-year-old single mother, thrived on adventure. Her weekends often spent skiing in the Rockies. One morning, a tragic skiing accident leaves her in a coma. Without an estate plan, her 8-year-old son, Jake, faces uncertainty. Who's going to care for Jake? He's 8, right? Under the laws of intestacy, the biological parents often have presumptive rights to custody. So that may be a good or bad thing, right? So it could be Jake's father, who he's never met. Decisions about Emily's medical treatment and life support fall to distant relatives unfamiliar with her wishes, right? What if they withdrew life support? Her assets intended for Jake's future are going to be stuck in probate, and other family members might try to claim a portion of the estate. So for those reasons, Emily, certainly if you have an adult child with children, really do need to look at estate planning. Again, whether it's a will-based or trust-based, kind of depends on the amount of assets, but thinking about having your adult children do estate planning, designate who inherits. You know, you may not want to inherit from me. I know this is kind of weird, but I have multiple kids. I'm not sure if one of my kids died, I would want it going to my wife, and I would probably want it going to their siblings. Well, the child can do that. They can say, I'm going to leave it to my siblings, not my parents. Also appointing decision makers for healthcare power of attorney, advanced healthcare directive. Avoiding probate, obviously very important, but making medical decisions, super, super important. And this can prevent family conflict, although sometimes family conflict is just going to happen. I get that. It can make managing a crisis more manageable. So you're empowered as a parent to make typically healthcare decisions for that person who needs those decisions made. So what sort of nudge? How do you nudge your kids on doing this? Parenting is kind of an interesting thing, right? And one thing is they could just watch this video, so it's not you telling them. But starting a conversation, maybe within capacity planning, it's a little bit less intimidating. So what happens if you get hurt and I can't tell the doctors what you want? I would frame this as empowerment, control, give your child agency to make their own decisions. This is not you telling them to do something, but it's you enlightening them, saying, look, if something bad does happen, you have the power to designate who makes these decisions for you. And really, it's your child's decision. If they're an adult, fully competent, it's their decision, but they should write it down. It should be documented. And, accidents happen. Some people say, I don't have enough assets. Well, you're planning for just more than assets. The other thing too, is sometimes we create an estate plan that gives something to kids either now or in the future. And those children should certainly, if you're creating maybe a more complex plan as a parent, you're going to want to have those children create the estate planning documents necessary to not make your estate plan disruptive if they die and you may still be alive. So I know that's kind of cryptic, but a lot of our clients do set up structures where they are making lifetime gifts to their children, where the parents still control it, but these clients essentially have an equity stake in some of the parents' assets. Well, you want to make sure that that's nailed down. And so your child doesn't leave it to somebody that you don't want them to leave it to. You need to have that conversation. And so many times when clients do a more complex estate plan, typically for a higher net worth client, we're also doing estate planning for the children as well for those reasons. But again, even if you don't have that, they still have the medical issues. I don't know where to start. We can start with an initial consult. It's too expensive. Things are expensive or things are costly. It's expensive, frankly, if it's a waste of money. It's costly if it's not. Sometimes people just pay for it, right? You can give them funds to pay for it. You can have a third-party payer agreement. So you can say, hey, go see Cunningham Legal. I'll foot the bill. And then we have an agreement where the child is the client and that the attorney-client relationship attaches to the client, but the parent is paying the bill, and that would be called a third-party payor. So that the ethics rules say that just because you're paying as the parent, you're not the client, and we maintain the confidentiality with the child. So an estate plan, again, is a living trust, a pour over will, durable power of attorney, HIPAA authorization, advanced healthcare directive, typically deeds to your real estate, as well as beneficiary designations on IRAs and 401ks. That brings us to the end of our content. We have office locations in Northern and Southern California, many lawyers to serve you. We're all about the peaceful transfer of wealth from one generation to the next. The next time we are meeting, April 24th, the topic is small business lawyer. Do you need one? Do you have a small business? Are you thinking about a small business? Do you need a lawyer? We're going to cover when and whether you need a lawyer for your small business, and you can register on our website. Please subscribe to our YouTube channel, and we will open it up for questions now. If you're watching this on YouTube, by the way, if you've made it to the end and you're on YouTube, please sign up for one of our webinars, because I'm about to answer questions live. And a lot of people, they put a lot of questions on there. It's your opportunity to ask me questions without being charged for it. So kind of cool. But if you're watching this on YouTube, keep watching, and we'll see you next time.